Okay, without introductions, it's your time, Michele.
Yes, thank you. I think I'm going to disappoint you because I have no theory or no new theory to offer about the topic I'll try to deal with. Rather, my idea is to offer a sort of landscape trying to describe the state of the art and giving a short and synthetic description of the state of the art about the use of scientific evidence in some areas actually is equivalent to raise a lot of some dozens of problems for which I have no solutions. Then the aim of my talk is just to submit to your attention the fact that there are many important, also practically important problems that I hope should be solved in a future, more or less near future, but anyway, that don't find a solution now. Well, I apologize also for being extremely synthetic. I'll talk of things, of various things, each of one would deserve a seminar, at least. And I'll show you why in a while. So forgive my extremely general and vague way of dealing with the topic. First, if we want to establish a starting point of the problem of scientific evidence in the modern meaning of the expression, we can start from 1993 when the American Supreme Court decides the well-known case of Daubert. Why this? Because this judgment determined in the United States, but not only, in Italy as well, a sort of explosion of writings and of studies, critiques, and discussions on that. 1 month ago, while I was working in the Berkeley Law School, I simply put into the computer of the library the two words scientific evidence, and I got 2,229 connections with articles, plus a dozen or so of books, of monographs. And this is a clear proof of the dimensions that this kind of topic has reached. I'm not discussing Daubert. Susan here wrote a lot about. There is a wide critical literature about the Popperian epistemology that was used by Justice Blackmun in his opinion in Daubert. So this is not the focus of my report here. But I would make a couple of remarks upon that. Therefore, not an analysis, but scattered remarks, so to say. One, some American scholars wrote recently that Daubert did not make enough in the line of shifting from a pure adversarial model of presentation of expert witness to a more, they say, inquisitorial. I don't agree with the word, but this doesn't matter. I say towards a more active role of the judge insofar as expert testimony is concerned. This is probably true, but I'd like to stress that this is a typically American problem, because the technique consisting in hearing parties' expert witnesses, which are selected, hired, paid, and coached by the parties, is a typical system. I don't know exactly now in England, but for sure it's typical of the United States. If we consider that in civil law countries the expert witness is not a witness, is an officer of the court, and we assume that he is selected and appointed by the judge, he has to be impartial and neutral, and so on, we are talking of two very different contexts. So what it seems to be happening in the United States as a consequence of Daubert in the continental in the civil law system always was the basic rule. And from this point of view, the comparative analysis of systems begins to have a role, because we are faced with different models concerning the way how, in a judicial context, scientific knowledge or scientific information are used, with the relevant difference insofar as the reliability of such information is at stake. From my point of view, I mean of a continental lawyer, the idea that a party expert provides us with evidence sounds almost absurd. So, but I'm not going on this, just stressing that actually the way how science is used in a judicial context are different and raise different problems of reliability. But enough for this. Another point, scientism, the myth of science as the perfect means of knowledge. Once again, I remember Susan writing a paper against the myths, more than one, of science. And I think she is right with this criticism to the myth of science. And probably Susan and other authors are also right when they stress that there is no sharp distinction between what we consider as a science and what we do not consider as a science, but we consider as a reliable means of knowledge. Okay, there is a continuum, let's say, that could go from theoretical physics to economy or to psychology. Well, but anyway, one cannot reasonably doubt that there are different forms of knowledge, and that some of them are more reliable than other forms of knowledge. And anyway, I would say, well, I don't overemphasize the distinction between good science and junk science. Well, but there are pretended forms of knowledge that are for sure junk. For instance, reading the leaves of tea or astrology and or that, I think that we shouldn't say everything goes into a huge container in which we don't know whether we are faced with a reliable form of doing anything or not. Therefore, flexible distinctions, but distinctions. Vague standards, but standards to decide, because if not, we are going back to the ordeals of the Middle Ages. reading the flying birds or the bones of so on, and so on. Another point. We may be skeptic, as we are, about science, but if we consider what's happening in a judicial context, what happens if we don't refer to science? Either because there is no science available on the specific fact, or because for any reason we don't use the science that could be available on the fact. What happens? It happens that the trier of fact has to decide, however, cannot say, well, I am uncertain on this point, so I defer my decision to the future years in which the scientists will solve. No. The trier of fact, the judge, the juror, has to decide. Upon what does he decide? Two alternatives. One, there is no evidence and proof about any fact of the case. The case is decided according to the rule of default, I mean, to the rules governing the burden of proof. But in any case, common sense, las reglas de la sana crítica of the countries speaking Spanish, Spain as Latin America, the maximum experience of the German-Italian doctrine, the stock of knowledge, the common sense, the average culture, all these things that are referred to by judges, by jurors, as well as by the ordinary citizens. And this is the basis for a decision, this amount of things, about which, and I quote, William Twining said that this stock of knowledge is an ill-defined agglomeration of beliefs that typically consists of a complex soup of more or less well-grounded information, sophisticated model, anecdotal memories, impressions, stories, myths, proverbs, wishes, stereotypes, speculations, and prejudice. A soup in which fact and value are not sharply distinguished, as well as are not sharply distinguished facts, fantasy, and illusion. So, well, let's be skeptic about science, about scientism, about all that. With what are we left? With this. Should we be happy to be left with this only because we are skeptics about science and about scientism? I have some doubts about this kind of choice. The non-lawyers among you should consider this. When there is no science available, the judge has to decide anyway. That means that he will decide using other kind of, let's say, knowledge. Well, there is, therefore, an alternative in these terms. Another point is, as many epistemologists correctly stress, that the scientific inquiry is not the same as the inquiry into the facts that is done in a judicial process. Sure, the aims are different. Looking for general laws in a case, looking for the confirmation or not of a singular statement of fact in the other case. Okay. But nobody may think that the search of truth in a judicial context, they use a common expression, is the same as making a test in a physics laboratory. That's too trivial, I not insist on that. But this is not to say that the context of a judicial proceeding is ontologically different insofar as the search of truth is the problem from what happens out of court. In a judicial context, we substantially use the same means of knowledge that the common people use out of court: information, testimony, documents, tests. It's the same. So I don't think that there is, repeat, an ontological difference between what we do in a trial in order to come out with a decision on the facts and what we do out of trial in all the other domain of experience. It happens to us many times a day, trying to establish whether the fact is true or not. Whether my flight goes on that time or not. And how do I solve the problem? I get information. And I try to get reliable information. And I may say, well, I'm trusting the guy who, by the telephone, tells me your flight already has gone. No? Well, but is this a difference? The only difference, as we were saying before, is that in the context of a trial, we are and should be much more skeptical about the reliability of what we hear than we are out of that context. But the form of knowledge, the means to establish the truth of a fact are not essentially different. Well, some people say, but there are rules determining what may or may not happen in a proceeding. Well, there are, but as Jordi clearly shows in his work, these rules do not imply that in the process we are looking for a truth that is ontologically different from the truth we are looking for out of the context. Here a very obvious remark is this. There are different forms of proceeding. There are different rules, for instance, excluding relevant evidence. Different because, for instance, I give only a quick example. In continental system, we don't have the hearsay rule that the Americans still have, but the English set aside, at least in civil proceedings. Well, there is a huge variety of rules like this, as well as there is a variety of techniques for controlling the reliability of the testimonies or documents and so on. But what does it mean? Well, some of these rules are clearly anti-epistemological, because they are working, limiting or excluding the possibility of establishing the truth of the fact. Think of the privileges. The privilege says you cannot prove this fact because this is privileged. Military privilege, government privilege, attorney-client privilege, patient-doctor privilege, and so on. Well, they are anti-epistemic. But if they are not applied in a specific case because there is no privilege in a specific case, well, that means that the search for truth may be made according to, Bentham would say, to all the relevant evidence, specifically useful to establish what happened in the specific case. Therefore, stressing the fact that there are rules governing what happens in a trial, first, doesn't mean that such rules are always the same. Actually, they are very different. There are more or less such rules with different aims. Many of them are simply historical relics that would deserve to be set aside in favor of a more free and flexible admission of all the relevant evidence. Coming to science, this means that the use of scientific information that we may make inside a proceeding is not substantially different from the use of science that we may make out of a judicial context. I'm not saying that everything is the same. I'm just saying that there are no such huge ontological differences between what we do in a process and what we do out of court. Well, given this, and going very quickly back to Daubert, as you know, Daubert established a set of standards that the judge, as the gatekeeper, should apply in order to establish whether the science is valid or is not. Well known, criticized, as I said before, while federal courts seem to follow Daubert, many state courts in the United States do not follow that. Anyway. But there are two problems. If we admit that at least Justice Blackmun had a good intention in writing what he wrote, and Susan showed how he was misguided by many amicus curiae briefs suggesting him to use a Popperian epistemology rather than another one. But anyway, I think that Justice Blackmun had good intentions, at least with the aim of saying, let's keep out of court information that are not scientifically valid. But, first problem, at least beginning in the end of the 19th century, some philosophers, as Dilthey, Windelband, and others, discussing the notion of science, introduced a basic distinction between, for instance, there are various ways of saying it, but between the so-called sciences of explanation, I mean the hard sciences, the natural sciences, physics and all that on the one hand, and the so-called sciences of comprehension, that is social sciences, soft sciences, sociology, history, psychology, anthropology, ethnology, critical literary criticism, and so on, because there is no sharp distinction or a rigid standard determining what a social science is. Well, this is not only a cultural or philosophical topic. The fact is that more and more frequently, what we call social sciences are used in judicial contexts. I give you, to those who are not experts in this, just a few examples. In employment discrimination litigation, experts in sociology in the specific area of gender or race discriminations are widely used as experts, helping the judge to establish whether or not there has been a relevant attitude of discrimination in employment. Other example, reconstruction of historical facts. whether or not the Holocaust occurred, and how and when, and so is a huge historical problem that has a relevant legal significance. Solving these historical problems is important for a lot of effects. Other example, establishing whether or not an ancient building has a historical and artistic value. It seems an abstract aesthetic evaluation has effects if the case is whether I, the owner of the building, can destroy it and build up a new one or not, or I can't do, because I am under the obligation of preserving and restoring this. There are cases on that. Judgment about the mental condition of persons, in criminal law as well as in civil law. John Doe was in his full mental state when he signed that document, decided it was not. In civil law as well as in criminal law, the use of psychologists as expert witnesses is extremely frequent. Well, where is the problem here? But one is the extreme variety of the sciences that we include in this general container of social sciences. Establishing a historical fact is not the same as establishing the mental state of a person. Therefore, the main problem is, well, the sciences of comprehension, as is demonstrated by the philosophers, follow, to use the Kuhnian term, different paradigms if we compare them with the hard sciences. That means that at least some of the Daubert standards are not applicable here. For instance, the determination of the rate of error is not applicable. An historian or a psychologist doesn't determine the rate of error of the method he is applying. Therefore, and this is the real open problem, if we want to check the reliability of the knowledge that is used in a trial, in one of these cases, we have to do that in different ways. Therefore, in order to learn whether or not this expert witness who says that he is a psychologist is doing a correct or incorrect analysis of the case, well, the judge should follow specific protocols, specific rules, a specific set of standards that are typical of that branch of that social science, which is not sociology, which is not anthropology, and so on. So here we have a wide bunch of problems from the point of view of trying to understand how could we check the reliability of these very specific types of expert evidence. Second, very quickly, David Kay wrote in a recent article, "Dark Days for the Forensic Sciences." Why dark days for the forensic sciences? Because after years of discussions at theoretical levels, the 2009 report of the National Association of Sciences of the United States put under attack the whole sector, the whole range of forensic sciences. I quote from the report what they are dealing with. Pattern experience evidence, fingerprints, firearms examination, tool marks, bite marks, impressions, blood stain pattern analysis, handwriting, hair analysis. And then analytical evidence, DNA test, coatings, paint, and so on, chemicals, materials, fluids, serology, fire and explosive analysis, and then digital evidence, and so on. And they, after 320 pages of extremely detailed analysis, I can trust them. They are a bunch of scientists and so on. So prima facie, I can believe that they are right in saying what they say. They say, well, with the only exception of DNA that has a reliable scientific basis of validation, and therefore can be taken seriously, so to say, even including the fact that that is the only type of forensic evidence that comes out with a huge probability of reliability, the 99% or so on. All these other forensic techniques lack any form of scientific validation. They are techniques, they are widely used, but they are not scientific in the very meaning of the word. And moreover, the report says that that almost completely the decisions of the American courts, I quote, were so far utterly ineffective in ensuring a minimum of scientific reliability of these techniques. And as you understand, when one says that fingerprints are not reliable as a mean of proving the identity of a person, you are putting into crisis one of the most common forensic tools of analysis. When you say that the handwriting comparison is not scientifically reliable, although it has been used since 1911 as a powerful mean for identifying the authenticity or not of a signature of a document, you are putting into crisis the forensic common sense that up to now was inclined to consider that these were valid, scientifically valid methods for establishing, for instance, the identity of a person. And what this report stresses, in my opinion, in a very strong way, is that the limit, the defect of these techniques is that, with the exception of DNA, if corrected, performed the test if not. But with the exception of DNA, all these techniques rely upon subjective comparison between or among items of evidence, between fingerprints, between handwritings, and so on. Subjective comparison, textual, means that different experts will come out with different outcomes. And there is no standard of reliability to decide whether one or the other one is correct. So we are left with two or more than two subjective opinions about whether or not two fingerprints combine, no? And therefore we are left with a basic uncertainty about the uniqueness of that person. Because the test of DNA, what tells you? It tells you that that person is the unique person that could have been present so and so. And the same is that ballot is the unique ballot that could have come from the gun of the perpetrator and so and so. But the judgment about the uniqueness is based upon subjective comparisons. That's the problem. What are we doing with all this? Considering that in a recent article in an American law review, they say that there have been several hundreds of false convictions, and the 60% of such false convictions were based on forensic evidence. And then they were shown to be false on the basis of DNA tests. And in some cases, this happened after the capital execution of some of the convicted. So what prima facie would appear as theoretical problems, what is scientific validation? Oof, theoretical. What is a social sign? Oof, theoretical. No. These are practical problems because we rely on such things. We don't have alternatives if not the common sense. We have to rely on such things in order to decide cases. And the example of hundreds of false convictions seems to be rather impressive. Therefore, the problem is to provide for any kind of scientific validation, at least for some of these techniques, not relying only upon the authority or the self-proclaimed quality of being the best expert in the field that are the standards, have been the standards so far. I stop here, but I hope to have given you the impression of how complicated and how different is the field in which we are trying to live. Thank you.
Larry.
Thank you, Michele. I'm a bit perplexed, I think, by the analysis that we heard, in large part because it seems to me to be running together issues that ought to be fairly sharply distinguished, and running them together in ways that are characteristic of a lot of discussions in the legal literature about the question of reliability on the one hand and science on the other. Most of the sciences, including the hard sciences, would utterly fail to pass any reliability test conjured up by the United States Supreme Court, the law lords, or any other judiciary. Think, for instance, of the frequency with which fundamental theories in cosmology, in theoretical physics and theoretical chemistry change at least once a generation. The question of reliability, it seems to me, does not map on in any interesting way to the science non-science demarcation, supposing we could draw that demarcation. Indeed, some of the least reliable bits of knowledge I'm aware of are things like string theory and theoretical physics. I cannot imagine having less confidence in a theory than I would have in that one. And on the whole, scientists in the theoretical areas, the pure sciences, the high prestige sciences, aren't concerned with questions of the reliability of their theories. That's not the conceptual game they're playing. It's quite a different matter in the applied sciences. If we're talking about drug research, medical research, engineering, there is a very serious and understandable preoccupation with questions of reliability. And it seems to me that needs to be the analogy that we're drawing on. We'd like, if possible, to get knowledge that is reliable. I think the Daubert and later Kumho insistence on knowing something about the error rate associated with the methodology utilized by a putative expert is a crucial piece of information to have. But it doesn't have anything to do with whether the claims propounded by the expert are in fact scientific or non-scientific, right? Take the case to which you briefly alluded towards the end of your remarks, namely the use, practically universal use, of fingerprint evidence. Okay? It's been around for more than a century. It's been very widely used, heavily trusted, through a period during which almost nobody had bothered to collect any serious and robust information about its reliability. Okay? So when Daubert first came out, and a few judges began to take it seriously and to say to fingerprint experts, okay, what have you got? Tell me about your false positive rates and your false negative rates. The typical first generation of responses was, well, we don't make errors. That kind of didn't...
Zero rate of error.
Yes, that didn't wash. And now we're at a point where things like the National Research Council in the United States have set up very prestigious bodies to design very robust tests to try and figure out what are the error rates for fingerprint evidence. Long past time, one might add, but that's being done. In fact, the report just came out from the National Research Council in the U.S. indicates that the false positive rate is about 0.1%, and that the false negative rate is close to 7%. And that in something like 30,000, in a study of 30,000 cases. That's pretty impressive evidence, at least for the use of positive identification. And it seems to me Kay's worries about, well, Christ, are we going to have to throw out fingerprint evidence, have probably been laid to rest, given that this study was conducted about as rigorously as it's possible to conduct a study. But the point I'd want to stress is that it's possible, in principle, it's possible to collect error rate information, even about activities that are very, very lowbrow empirical activity. Suppose, for instance, you have somebody who claims he has a method for analyzing tire treads. Okay, he's not a trained scientist or anything else. He's just had an awful lot of experience with how tires weather, how they change, how they wear down. Okay, and there's no reason on earth to think that his expertise could not be tested in reliability tests with information about the positive, the error rates, the two error rates associated with the technique of tire evaluation that this guy is using. So the fact that, for instance, as you were putting it, fingerprint judgment is subjective, okay, basically what that means is that we don't yet have a theory about how fingerprints emerge, biologically speaking, doesn't do anything to undermine the question as to whether or not we can have good reliability measures of fingerprint determinations. Even something as far removed from the sciences as spare tire or tire track analysis, in principle, could be the kind of thing, if the government were prepared to put resources into it, in which we could come up with, in principle, important and significant information about error rates of the two sorts associated with this particular technique. So it seems to me where Daubert went badly astray, and I wonder what your reaction here is, where Daubert went badly astray was in thinking that the determination of expertise kind of somehow maps on to the determination of scientificity, right? And that's just a bad mistake, both because much science is not reliable and because there are a lot of things that are patently not scientific that are such that we could work up reliability measures for them if we were prepared to put the funding and the research into doing so. And so it seems to me that the best thing that could possibly happen, and did not happen with Daubert, unfortunately, Daubert kept Fry's commitment basically to the view, while allowing for the occasional exception, that expertise is scientific expertise. And it seems to me that's a deeply flawed misunderstanding. And I wonder if what your reaction to that is, not least because you were, in the early parts of your remarks, characterizing fallibilists like Susan and me, who are sort of skeptical about strict science, non-science demarcations, as somehow making it harder for the courts to utilize scientific information. That's certainly not how I construe my project, and I don't think it's how Susan construes hers. You were suggesting that, well, hell, if we give up the myth of science as infallible, all we're left with is common sense. I took that to be your argument. Well, no, we're not proposing giving up the sciences. What we are proposing, fairly strongly, is recognition that scientific activities, in scare quotes, are also error-prone in many ways as much as other forms of knowledge or inquiry are, and that it's just as crucial to find out what the frequency of errors is with respect to claims that are putatively scientific as it is with respect to claims that pretty clearly derive from common sense.
Well, I share most of your remarks.
I thought you would.
So, as well as I share most of the criticism against Daubert and so on. And I also agree with you about the problem of non-sharp demarcation between science and other forms and so on. But anyway, since the experience is that we lawyers used forms of knowledge in the broader sense of the word that were no forms of knowledge at all. So the problem exists of deciding whether or not that case was solved on a rationally grounded basis or on fantasy or on any kind of astrology, faith in the miracles, and all that. These are things that happen in the real world of the administration of justice, and so my problem is that let's try to keep out of that context of what is misleading, what is clearly false, what is clearly unreliable, which is not excluding technical forms as the Marx and so on. Cuomo and all the following cases admitted. Yes. Just a remark about the rate of errors. We come from an experience in which every expert in this forensic evidence claims, for example, in the case of fingerprints, 0 rate of errors. You say, no, it's not impossible. We can, and therefore we should determine the rate of errors in any kind of these methods. Okay, then the problem is, which is the rate of error that we admit and we consider reasonable in using, because 0 rate of error doesn't exist, okay. As someone writes, well, if the rate of error is so low that tends to be almost only abstract and not concrete, we can consider this technique as reliable because the risk of error is so low. My question is, how low should it be, the risk of error in any, well, the risk of error of 7% in fingerprints analysis.
False negatives.
Both negatives. Well, it's okay, we admit it, considering the thousands and thousands and thousands of cases in which the handwriting comparison is actually used. How many mistaken decisions are we admitting? This is not a problem of scientific validity, it's a problem of, let's say, policy, in one context we can admit only a 0.00001 rate of errors, and in another context we could admit a 20%, positive or false or both. But this is one problem. The other problem is that, as far as I know, I may be not informed, but in most of the cases of forensic evidence we are considering, at least up till now, there is no knowledge of the rates of errors. So when we don't have a 6% of false positive and so on, we are left with the original problem of establishing what are we doing with a kind of information that is based only on the subjective evaluation of an expert. He could be an old expert. He could have practiced the comparison of tires for 30 or 40 years. Okay. It can be credible to some extent, but you understand that we here are working with rather weak forms of evidence. At least we should be aware of the fact that they are weak, not taking the expert's opinion as a sacred text.
In the queue of interventions, there are Susan, Paul, and Ron in this order. Susan.
Okay, I have a list. It's quite short, but the first thing on the list I will say, even though Larry also said it, it's something I have said several times in print. I can't even remember when I said it first. But scientific and reliable are different concepts. Not all and not only scientific testimony is reliable. Okay. There are unreliable scientists and there are perfectly reliable experts, say, on hairdressing techniques. Okay. Moreover, a secondary conceptual problem that I think you were just touching on is that reliability is quite clearly a matter of degree. But evidence is either admissible or not. So that the one difficulty is simply mapping something which is categorical onto something which is gradational. Okay. Now, the second thing on my list is about Justice Blackmun. I'm sure his intentions were good, yes. I don't know whether you're aware of his dissent in an earlier case, Barefoot. Are you? Okay. This was a capital sentencing case. It came from Texas. And Texas capital sentencing law required then, in 1983, and still requires now, as in effect, it's certainly the most important, and I think conceptually it's really the only thing that determines whether or not someone is executed or gets life, is that there must be testimony as to whether they will be dangerous in future. Mr. Barefoot was sentenced to death after two experts had testified that he would be dangerous in future. There was evidence that the American Psychiatric Association had issued a declaration. We are not capable of making such determinations reliably. Such predictions are wrong 2 times out of 3. The Supreme Court said, this is okay, this is okay. Justice White even writes, the APA doesn't say it's wrong all the time, it just says it's wrong most of the time. Anyway, they had the opportunity to contest this and cross-examine the experts and blah, 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 blah. Justice Blackmun wrote a furious dissent, saying, this is just outrageous, especially when it's a death penalty case. For heaven's sake, we want better evidence than this. I suspect that he hadn't forgotten when he wrote the ruling in Daubert that we want reliable testimony. But now, think about it. One of the things that tells you is that even with respect to psychiatric evidence, which I take it you would lump in with the soft sciences if you would count it as scientific at all, error rates do make sense. Okay, it's actually, I think, very hard to do a good estimation of how reliable or unreliable such predictions are. It is, for instance, extremely susceptible to how strongly or how weakly you define dangerous. It makes a huge difference whether the question is he likely to kill a prison guard? Or is he likely to throw a cup of coffee at him? Right? So it's not that I think testing the error rate is easy, but it's not impossible, even in such areas. And then this is the last thing on my list is, seems to me that the problem isn't, I mean, it's not whether it's science or not, it's with the kind of person the kind of science that tends to be brought into court, and the kind of scientist who tends to come to court. And here I'm trying to make, I think, two different distinctions. Where you're talking about something that neither Larry nor I would hesitate to call science, epidemiological research into the effects of a drug, say. It's likely, because look, in the nature of the case, it will not come to court if the science is fully settled one way or the other. Right? In the cases that come to court, the relevant science will be not fully settled. That's why they're in court. Okay? Otherwise, either there would never be a case or it would be settled. And in the nature of the case, in an adversarial system, the parties will bring into court scientists who are, as it were, more certain one way or the other than the average scientist. Right? So that the impression of wild disagreement is in part an artifact of the system. That was one point about the kind of science you tend to get, scientist you tend to get. But then there's another issue, which that there is a large class of sciences or supposed sciences or techniques or whatever you want to call them, for which the legal system is in effect the only market. The only market. Okay, there is no other customers for this kind of thing, right? And that in itself is, I think, inherently likely to make the area less rigorous than it could be if we put our minds to it. If you think about DNA, for example, it's an exception not only in terms of its reliability, but also because it has a theoretical basis which is crucial to a whole lot of other stuff, which has nothing to do with the legal system. This is not true of fingerprints, where the biological explanation of the differences among them is really very uninteresting. Because I think there are a whole bunch of different issues that, I want to keep separate that you perhaps had some tendency to run together or to misidentify. I'm not sure.
I have not an answer because what Susan says, I interpret it as an interesting development of the problem. I don't repeat my remark about the rate of errors. Well, if we have it, and it's good to have it, this is an important aspect.
But because of the difference between categorical admissibility
yes, sure.
and degrees of reliability, that's exactly what you said in response.
Yes,
so Larry, we don't know how reliable it has to be.
Mm-hmm. But why do we have to know how reliable it has to be? It seems to me, provided the Dalbert-Kuhn condition of having reliable information about error rates, that, in effect, for me, is sufficient to trump the admissibility question, provided that the triers of fact are informed as clearly and as simple-mindedly as possible what the error rates are and what that means. And in that case,
yes,
what's the struggle about trying to set a bright, clear line below which evidence is dismissed and above which it's admitted? As long as the reliability rates are there, it seems to me the only argument for dismissing evidence that is prima facie pertinent is that it would be a waste of time, it's redundant. But so long as if we discover that handwriting analysis is reliable has a 60% effectiveness or correctness rating on positive identifications and a 52% on negative identification, that suggests it's not awfully reliable. On the other hand, it's probably arguably at least as reliable as much of the other evidence admitted at trial. So I wouldn't see any particular importance in setting up a barrier.
I don't know, here on the point of admissibility, reliability, there is a rather tricky technical point which is different according to the system in which you are reasoning. Because, for instance, the double idea of the judge as a gatekeeper, well, functions if we imagine the American system in which the parties are coming with their own experts, and then the judge's function is to admit or to exclude on the basis of reliability. The problem is different in systems in which is the judge who decides whether or not he needs an expert to assist him in establishing a fact or in making an evaluation. And therefore, there may be a confusion between relevance, admissibility, reliability, and so on, but we don't have the time to go deeper into this point. There is a technical difficulty here. But given the hour, I try to give you an example. Suppose that a party asked the judge, reasoning in the Italian or Spanish system, to appoint as an expert witness an expert in astrology. Because the party says, in my opinion, the best way of solving the dispute is, or an expert in reading the crystal balls. Okay? Something like this happened. Well, should the judge admit this only because he is not able to establish whether or not that way of proceeding is reliable? Or could the judge say, listen, we are not wasting time. I exclude it because of the fact that the method you are proposing is completely unreliable. This is the problem, because I saw several cases in Italy as in other places. They called mediums or experts in finding out the water under earth in order to, for instance, to discover the way, the place in which there was a dead man. Are we sure that since there are no clear distinctions between what is scientifically valid and what is not, then we should admit everything?
No, you shouldn't admit anything unless you have
No, that's the
Paul.
Jordy, thank you. Just a couple of quick points to add to the discussion. Susan, markets. I mean, market forces pose serious regulatory problems for forensic sciences. There's no doubt about that whatsoever. And in some respects, the adversarial system can be seen to exacerbate that whether you intend. I think it's not true that DNA profiling technology was invented in adversarial systems and was taken up very quickly in adversarial systems and became well established globally on that basis in a relatively short period of time.
About a decade in the States, yes. About a decade in the States.
Yeah. I think it's very interesting that it's a serious question whether today we would have DNA profiling technology if the whole world operated on the basis of court-appointed experts. It's a very serious question, the answer to which may be no. So I think market forces in forensics is an interesting one. But just a code to that, you may or may not know that the British government has announced the closure of the Forensic Science Service, which used to be the Home Office Forensic Science Service in England and Wales, which means that as things currently stand, our entire forensics will be, forensic science I mean to say, will be left hostage to the market, which is an interesting development to say the least. I'll say no more about that. Dark days for forensic sciences. I think fingerprinting is a bad example of dark days for precisely the reasons that Larry elucidated. But if you want to talk about forensic dentistry, odontology, or if you want to talk about facial mapping and a whole range of other techniques that have become pretty standard in criminal justice process, certainly in the UK and in the USA, could well be dark days. And whether you think that's a good thing or a bad thing, we can discuss that. But I think there's I think the NRC report does pose very serious challenges to the forensic science community that are going to be worked through.
Pick it out and get your reliability.
Yeah, and what happens in the meantime, and will we ever get it? I mean, I think it's an interesting question. Okay, now, a couple of other, I hope, important points. Yes, error rates, but let's be very, very clear. Error rate is a technical measure of error in the measurement. It has no bearing directly on reliability. A forensic odontologist could be 100% successful at identifying matches between a dentition from a crime scene and the accused dentition that could be 100% accurate, zero error rate, and yet that evidence could be completely worthless. Because unless the dentition in the evidence maps onto something special about dentition in human beings, then the evidence has no probative value. That's an extreme example to demonstrate that. But that's why, just to pick up one thing, Larry, it's not about it's only partly about the biological issues of whether people's fingerprints are uniquely identifiable or not, but that's not the issue in forensic practice. The issue in forensic practice is not whether ridge impressions on your finger are uniquely identifying. It's whether, when that transfers to a fingerprint on a table or on a glass, or whether that is uniquely identifying. That's the thing the forensic scientists test. They take the fingerprint from the crime scene. They don't take the offender's finger. And that translation between the underlying phenomenon and the evidence is the reliability link. Whether
but the validity link, not the reliability.
Well, validity and reliability connect in that regard. When you test error rates, you test whether this forensic examiner correctly identifies that print to the accused, which is another set of relationships. So error rates are another thing going on in that analysis. It doesn't relate back directly to the link between the physical phenomenon and the evidence, the thing that's left and collected at the crime scene. These are different things. I mean,
it depends on how the test is designed.
It depends how the science works.
You clearly can design a test such that you take real fingerprints from real people, right? You, designing the test, know exactly which fingerprint.
Yeah, sure. I agree that it can be tested. The point I'm making is that error rates only test these relationships, not that one. That's what error rate means, as I understand it, statistically. I think that's what it means. That's what, if I've understood my statistician French correctly, that's what it means. Okay, right, last point. Just to reiterate something that both Susan and Larry have said, I absolutely agree. Science, non-science is not the question. Let me add to this a comparative law point. The reason it became a question is because of Rule 702, the Federal Rules of Evidence in data. That's why it became a question. Now, it didn't follow from the wording that it has to be, because it says scientific, technical,
or other specialised knowledge.
Exactly. So it wasn't necessary that Daubert would interpret Rule 702 in that way, but it did. Okay. Now, we can say that that's a problem for American jurisdictions that have the Daubert standard, insofar as it was corrected by Cunningham. It's not even an issue locally. Now, here's the point. As a matter of comparative law and taking transplants from other jurisdictions, we may want to take the transplant of the gatekeeping function. We may think that's a good idea, and we may think that in future we should get our judges to be like you. I don't find inquisitorial adversarial helpful at all here. Let's say, get our judges more interventionist, more active, more proactive in testing the underlying validity claims of scientific evidence. We might want that, but we must be very careful not to bring with that the science, non-science distinction, because that's a mistake for the reason that we've been discussing. The question is, and I'm just reiterating what Michele said here in my language, partly Susan's, I think, the question is always one of expertise, not science. And the question is always, is this expertise, and that means both this particular expert given it and the underlying field of expertise to which it relates, is this expertise sufficiently epistemically warranted for the purposes to which we wish to put it in adjudication or in legal process? That's the question. And you can frame it without any reference to science and non-science. That's a chimera, it's a distraction, we should forget about it.
I can agree on that, mainly about the last point about strengthening the gatekeeping function of Italian judges, for instance, because I know that they are not checking well enough all this. They are not checking the professional expertise of the experts they appoint. They often don't check whether or not they are really impartial, and so on. The reference to science, in my opinion and in my context, is not in the sense of sharing or the distinctions of science, not say. I mean, it has a rhetorical aim. I mean, listen, dear judges, you are not dealing with fantasy and these strange things. You are dealing with a problem that needs to be solved in a rationally justified way. Call it expertise, don't call it science. What we should have is control upon the reliability foundation of the kind of knowledge in the broader sense you are using in order to reach your decision. Daubert was useful to me, for instance, in raising this kind of problems in the Italian doctrine, where this problem never was heard of. And next Monday, I am going as a reporter to a seminar in the Appellate Court of Milan, where at last we started discussing seriously this kind of problem. So I agree with, but we are faced with this kind of very practical, if you want, but very important questions that have to be solved by judges.
Right.
So,
so being from the United States, and I think we just turned this off. I think Larry just turned this off. It tells you what he thinks about my comments. Yeah.
No, it's on.
Is it on?
No.
Larry, you're just messing. You're trying to distract me from my gosh, here we are, great collaborators. So I don't think I need to do being from the United States, I guess I should be happy about all this attention given to the United States Supreme Court decision. But I have to say, I think this is really sort of distracting from the kinds of issues we want to talk about. Number one, and number two, I think it's misleading. I'm going to sound a little bit like Paul Roberts here, but you can't understand these cases without understanding the procedural context. Daubert did not make a distinction between science and non-science for purposes of general admissibility. Daubert talked about science because there is, as Paul pointed out, a rule of evidence, 702, that says scientific, technical, and other specialized knowledge is admissible under certain conditions. And so what they had to do, the party said, this is scientific evidence that we're talking about. We think it's admissible. They don't think it's admissible. What are we going to do? So they had to talk about science because that's what the party said the issue was, and that's what the rule requires. That's all. Daubert did not adopt a Popperian view of science. Daubert had a few footnotes in it, that said things about falsifiability. They probably shouldn't have done it. Susan, I think you're probably right. Why, if you don't know what you're talking about, shut up. Fine. But there's a lot of other things in Daubert too, like, Popper did not talk about peer-reviewed journals, right? Popper did not talk about general acceptance. There are a lot of other things there too.
Absolutely, yes.
So why were they talking about this stuff? Well, they were talking about this stuff because this is what the problem was, as presented to them by the parties. Blackfoot versus Estelle. The question in Blackfoot versus Estelle is whether the federal courts, remember, we have a federated system, whether the federal court can reverse a state conviction, not a federal conviction, but a state conviction on constitutional grounds because of the unreliability of the evidence. That was one of the questions. And I won't go into it, but just imagine the disaster if every state factual question could be contested on a federal constitutional grounds that it's unreliable. No sane system is going to allow that kind of second guessing of some other system so that every single factual issue in a state case now gets to be retried and recontested in the federal courts. So that Blackfoot versus Estelle was not putting its imprimatur on that crazy doctor whose name I forget. It was the one in particular, Dr. Death.
Dr.
Grigson.
Yeah,
Grigson. He was saying, no, this is not a constitutional problem. It may be a problem, but it's not our problem. It's somebody else's problem. So I think you have to be really careful about reading these cases. Now, I think there is a central problem, though, and I want to articulate this because I think it bears on this session, the next two as well. The central problem is that I think we share an aspiration for our legal systems, all of us in this room. And one of the most important is that the legal system will strive to get accurate results through a process involving rational and disinterested decision makers that hear evidence in an open-minded way, process that evidence, deliberate upon it, and reach judgment accordingly. You can pretty much guarantee, not guarantee, but you can come close to guaranteeing rationality in that sense. You can't guarantee accuracy, but you can approximate accuracy, hopefully, by having these rational decision makers process information, understand it, deliberate on it, and so on. So what does that require? That requires that evidence be backed up into the common understanding, knowledge of the person making the decision. In almost all cases, that's not a problem. Go back to our favorite hypothetical. He raped me. No, I didn't. I understand that problem. I understand why people might lie. There's nothing mysterious about any of that language. Now, I may not know who's telling the truth, but I can look at them and I can get a sense of their demeanor, and other evidence may come in, and I can understand all that. The problem of expert and scientific and technical and other specialized knowledge is the gap, the epistemological gap between the testimony, the evidence, whatever it might be, and the understanding of the decision maker. That's the problem. Daubert doesn't solve that problem. Going to Italian gatekeepers is crazy. The problem in the United States is that you have a judge-jury divide. What Daubert says is the judge has to become well enough acquainted with the subject matter to ensure that it meets reasonable standards, and it's going to be a fruitless task to try to create an algorithm of what that might be, those reasonable standards might be, because it's going to vary over all kinds of different human activities. But whatever it is, it is. And so then you have to go out and see, okay, does this look to me like it's reliable? How do I get a sense of reliability about car mechanics? I don't do replicable tests, but I got to go out and look at it and figure it out. How do I get reliable information about farmers in Iowa, or farmers in, where's a farming area in Spain? Pick one, right? In Spain. Yeah, I got to go figure it out. And the trial judge has to do that to ensure that, in fact, this person is testifying just like a layperson. That is, on the basis of knowledge, basis of experience, and so on and so forth. Now, the problem in the United States is that this comes atop a tradition in which
expert testimony was presented in the form of opinion. You get two experts. Do you have an opinion? Is Blackfoot crazy? Yes, he is. The other expert, is Blackfoot crazy? No, he's not. Both experts. Now, what happens? The jury can't rationally conclude who's telling the truth. Nor can anybody else who doesn't understand the underlying field that gave rise to those opinions. So the real problem here is the distinction between what is our normal mode of proceeding at trial, which is an educational mode. Trials are pedagogical events, whether in Italy or the United States. You are normally educated simply by hearing people who you fully understand what the problems are and listen to them and understand them. With respect to experts, what happens, and this does happen in Italy, is we enter into a different mode of decision making. It's a deferential mode. You're deferring decision to somebody else. When I admit an Italian judge and I admit an expert and I say, okay, he's an expert and I rely on him and here's his opinion, I'm not making the decision anymore. The expert is making the decision. And to that extent is inconsistent, I mean fundamentally inconsistent with what I think you would agree with me is maybe our deepest aspiration for the legal system, right? Rational decision based on evidence processed by a disinterested, rational individual, right? So in the United States, what happens today is we have these Daubert hearings where the judges have to learn enough about the subject matter to be convinced these people are telling the truth, or what the ranges is, what are the problems in the error rates, and so on. But then you don't have to present that information to the jury. That's the problem, and that's why judges behave strangely in the United States. That's why the admissibility decision in the United States no longer is an admissibility decision, it's a sufficiency decision. Because if I admit, suppose I admit I'm a judge and I'm convinced that, this is as good as circumstantial evidence, so a reasonable person could be affected by it. So it's relevant. But if they were convinced by it, they would be making a mistake. That's the difference between admissibility, just plain relevance, and sufficiency. Is it sufficient for an outcome? So I see now it's relevant. If I admit it, and the jury doesn't understand how to appraise it and reach it and concludes, okay, the guy's telling the truth and I find a verdict for that person, I've now got to reverse it. Because the jury doesn't realize the relevance is not sufficient for an outcome, even though I do, and they haven't presented this information to the jury. So what do you do to solve that? What you do is you don't admit scientific evidence unless you think it's sufficient for an outcome. And so or you make them, and this is exactly what I would do. Well, now I hate to say it because here I am talking normatively. Oh my God, I can't even get it out. Make them explain it. If you want a cure for this problem, the point would be you don't let anybody testify unless the decision maker can understand what they're saying. Suppose I started, actually this is a true story. A colleague of mine is fluent in Latin, and whenever she gets excited, she starts talking in Latin. So suppose she's in a car wreck in the United States or Spain or whatever, and she's called to testify, and she gets excited and starts testifying in Latin. Would you allow that? Well, of course not. She's speaking a foreign language. It can't be understood. You'd make her speak a language that could be understood. Well, that should be, if you want to solve this problem, the solution to the expert, that you have to invest enough time and effort to understand it. Then all this stuff goes away. I mean, you still might make mistakes, can't guarantee that you won't, but it's these artificialities that have been introduced into the process for the reasons I've identified that cause really the problems.
Well, of course, I share Ron's analysis of the American situation. The point I'd like to stress is the difference between educational and differential attitudes in the two systems. Actually, I'm trying to react against the excessively differential attitude that Italian and continental judges have there is a paradox in our systems. That is, the judge decides that he has no technical or scientific knowledge enough to let him decide on the case. Then he appoints the expert, and then theoretically he should criticize the outcome of the expertise. One never knows on which basis, because the premise is that the judge has no such knowledge. The effect is that in many cases, and with the approval of Supreme Courts, judges do not justify their own decision when it conforms, as it usually happens, with the expert opinion. And this is the perfect differential attitude.
But that's why, Michele, that's why I can't give you advice about how to persuade your colleagues in Italy, obviously. But from my point of view, a priori point of view, the language of gatekeeping is inopportune for that. It's not gatekeeping that you're worried about.
Yes.
It's comprehension.
Yes.
That you're worried.
Yes.
Worried about.
Yes.
Or you could say that the gate is different. I mean, you know, in common law jurisdictions, we think of the gate as the admissibility determination, which is what Susan was saying. But
they are different gates, so to say.
If you regard the question, if you thought the gate was, can this be part of a motivated decision, that is to say, a written, justified decision, then at that point the issue would be whether it's sufficiently reliable and probative. But I'm just saying there is a way of translating the language, providing you're sensitive to institutional context.
I can't think of a reason why you want to use the gatekeeping.
Well, I'll give you some.
Let me give you from an American Supreme Court case that has almost nothing to do with
Let me give you a very, very good reason. People are already.
He's the one who's going to try to
people are already talking about it. No. If we were starting from Mars and no one had heard the phrase gatekeeping, it wouldn't be an issue. Alas, for whatever reason, and good or bad, the fact is that people across Europe and beyond are talking about DAO and have been for 10 years. So the gatekeeping language, that should be said.
So this is another example of reverse consequences of American cultural hegemony.
Most people think it's a good thing. I'm not beating up on Americans.
I'm the one who's saying it.
Yeah, I know, just to be clear.
Carmen Vasquez.
Well, I really want to know.
Use the microphone,
what
please.
What do you mean for reliability? You said. Because you was using all the time, and I was wondering, well, reliability, what does it mean?
Reliability means at least the possibility of checking the rational foundation of an information. Reliable means that I can take it as if it were true, as if it, considering it as a useful piece of information that I can trust in order to make a decision. When a witness is reliable, we go back to the discussion of this morning. When we have enough reason to believe that his answers to my question were true, were probably more or less, I don't know. Reliability means the rational possibility of taking an information as a valid one, as a justified one, for a decision. This is, we can use... Now, we can use a lot of words to explain this.
For example? For example, we could use a lot of words to explain this. Do you say that?
You may, if you are talking of a witness, you may say credible.
Well, because, for example, in your paper you say something about scientific validity, and then scientific validity seems to, at least in your use, like
scientific validity deals with the problem of rate of error, scientific validation and all that.
Of course.
It's not the same. One may say, if I have an expert testimony or an expert evidence that is scientifically validated, for instance, because we know the rate of error and so on, well,
No, not the rate of error, because we have reason to believe it's measuring what it reports.
yes, okay.
Which is not.
Well, I may have a reliable information, which doesn't mean absolutely truth. It means that it can be a good basis for taking a rationally well-justified decision. In the example I gave before, if I make a phone call to the airport and I ask whether or not the flight left at 9 this morning, and the answer is yes, it left in time, this is reliable information, at least until when I have some reasons to doubt of that. Reliable means credible. If I have to take a decision about doing anything, this morning I asked the author the schedule of the trains for Barcelona, and I consider the paper they give me as a reliable piece of information in order to make my decision at what time to leave tomorrow. At least until a contrary proof gets out saying that they faked the paper and all that. No more than this. If we are talking of scientific or expert evidence, reliable means that I have good rational arguments to conclude that that piece of information is true in the relative sense of the word, at least enough justified in order to let me conclude that I have to acquit or I have to condemn this guy on the basis of the outcome of the evidence. This is reliability.
Notice how flexible this test
Yeah.
is. Notice how flexible
Okay.
it is.
Yes.
And this is virtue, I'm not criticising.
Yeah,
It's
no,
virtue.
yes.
So, imagine in a case that an issue arose as to whether this accused committed the crime, murder, whatever. And part of the prosecution's case is that this accused, who themselves believes in tea leaf reading, right? Read or had read to them in the day bad news in the tea leaves, and it was because they received that bad news that they committed the crime. You can fill in the other details, whatever. That's the belief. Now, in that scenario, it would be legitimate to call in somebody who is an expert tea leaf reader to explain to the court, whether it's a jury or a judge, doesn't matter, to explain to the court whether a particular pattern of tea leaf reading is regarded by tea leaf readers as conveying bad news. There's actually a case like this in England. It doesn't involve tea leaves, it involves magic and whether someone could be a magician. And the issue arose that they called a member of the magic circle to testify as to what magicians believe. Now, notice how flexible it is. It doesn't just depend on the criteria of validity in the abstract. It relates to the proposition for which the expert is testifying in court. And notice further, just to drive the point home, that somebody could be an expert tea leaf reader in the sense that their error rate is 0. They are always accurate when they say that this pattern of tea leaves, or tarot cards, or whatever it is, means bad news. And that shows you again why error rate got no direct link to reliability, because they could have no error rate in the test, but we all know that the test is bogus. For the real phenomena, it may not be bogus to assess the motive of somebody else who believes in it. So I was just to bring a few points together there.
Okay, only just a short second question. Do you think that are relevant differences between scientific or expert evidence and other kinds of evidence, like documental one or...
But from the point of view of the use of evidence, there are no deep differences. Because if I read a document, if I read a paper offered as evidence, I may have the problem of establishing whether or not it is authentic. And this is a problem that may involve expert evidence about handwriting or not, according to whether or not I make the confrontation between that piece of paper and another one. But there is no real differences. Take the topic, the credibility of the witness. No? Whether or not you are dealing with an ordinary witness or with an expert witness, you are faced with the same problem of credibility. Personal credibility and so on. Is he telling the truth? Is he telling lies? Is he impartial or partial? Has he connection with one of the parties or with the subject matter of the case, and so on and so on? To this extent, there is no difference between evaluating an expert testimony and evaluating a non-expert testimony. They broadly overlap the same kind of problems.
Then I have an ingenious question about this point, because if there is no sharply distinction between scientific or expert evidence and other type of evidence, that I agree, why we are interested, for example, in the rate of errors for scientific or expert evidence and not for witnesses or documents, or why?
Good
because we need an answer to this why question in order to make rational these different requirements for these different or not types of evidence.
But one very easy answer is that we don't know the proportion of false witnesses, as well as we don't know the proportion of non-authentic documents. Simply, we don't have this.
Maybe it's more easy
although
we know a lot about, for example, the circumstances in which an eyewitness is likely to be unreliable.
And when we have data, we tend to admit it. I mean, I think that this is the point. I mean, the reason you don't do it is, first of all, like we were talking about yesterday, there's no science of when a witness is lying outside of very extraordinary constraints. There just isn't any. There never will be one, because nobody's going to spend the time and money to investigate those kinds of things. That's point number one. But more importantly, point number two, you do have information about lying from your experience. You know, you've dealt with people who've lied, you've dealt with people who've told the truth, you understand motivation, you understand the incentive effects that trials create, and why people might shade the truth here, they're worried about being convicted of perjury, so they might not outright lie there. You know all this stuff. Now, you don't have statistical tables, but you have plenty of information, maybe not terribly reliable information, but remember, any particular witness is just one of a mosaic. Now, compare that to what used to happen, thankfully no longer is, an expert fingerprint identification person comes in and says that smudge print is his. I have no knowledge of this. I have literally zero knowledge. So these are not comparable in that epistemic way. And that's the epistemic gap that I was referring to. What we should be doing or talking about is making the fingerprint examiner look exactly like the witness, who now you can consider whether they're telling the truth or not.
The other side of the answer is that in the areas that we were considering, the common feature is that we are referring to a kind of knowledge that we don't consider as existing in the head of the judge. Therefore, the difference is that in those cases, we refer to something else, something different from the average culture, the common sense, and so on.
That's a restate, we're saying the same.
Yes.
Okay, thank you so much. Like yesterday.